Judgment in the appeal Davies and another against the Scottish Commission for the Regulation of Care.
The appellants operate a children's nursery in Aberdeen. As required by the Regulation of Care Scotland Act 2001, it was registered with the Scottish Commission for the Regulation of Care. The Commission became concerned at the way in which the nursery was being operated, and in 2008 and again in 2009, it gave notice to the nursery of proposals to cancel the nursery's registration. The nursery disputed the factual basis for the Commission's concerns and appealed to the Sheriff. In the course of those proceedings, the Sheriff held against the nursery on an evidential issue. The nursery appealed against that decision to the Sheriff Principal. In the meantime, the Public Services Reform Scotland Act 2010 had been enacted. It provided, among other things, that a new body, Social Care and Social Work Improvement Scotland, which I shall call the Institute, would take over from the Commission the responsibility for the regulation of the day care of children. On the 1st of April 2011, the Institute was established, the Commission was dissolved, all of its staff and property were transferred to the Institute, and the provisions of the 2001 Act, which dealt with the regulation by the Commission of Care Services, such as the nursery, was repealed. Two transitional orders, the number 1 order and the number 2 order, dealt with what was to happen to various outstanding actions and proceedings as a result of the handover. Article 2.1 of the number 2 order dealt with appeals, such as the present, which were outstanding on 1st April 2011. It directed that Part 1 of the 2001 Act was to continue to apply for the purposes of the care services involved until the appeals had been finally determined. The appeals before the Sheriff Principal, which had been on the evidential issue, then took an unexpected turn. The nursery argued that the Commission could no longer be a party to them as it had been dissolved and replaced by the Institute. It also said that the Institute, for its part, had no title or interest to enter the proceedings, as they were concerned only with things that had been done under the 2001 Act before the Institute came into existence. The Sheriff accepted these arguments. The Commission then appealed to the Inner House of the Court of Session, and the First Division, by a majority, allowed the appeals. The nursery have appealed against that decision to the Supreme Court. In the meantime, in 2012, further notices have been served on the nursery by the Institute. So there are now parallel proposals to cancel the nursery's registration, whose validity is under challenge and are under appeal. The Supreme Court unanimously affirms the orders of the Inner House to the extent that they allowed the appeals against the orders made by the Sheriff Principal. Its reasons for reaching that decision are based on an analysis of the transitional orders. In the light of that decision, it holds that the notice which was issued by the Institute in December 2012 under the 2001 Act is also valid. This raises a question about the future conduct of these proceedings. There was considerable delay in the Sheriff Court, and it has taken almost 2 years for the issue about the effect of the transitional orders to be argued out in the appeal courts. The fact that proposals to cancel the registration of the nursery are now the subject of 2 parallel appeal proceedings directed to the state of affairs in the nursery on significantly different dates is a cause for real concern. The time has come for this court to intervene to minimize further delay and expense. In the very unusual circumstances of this case, it takes the view that if the Institute were to adhere to the 2008 and 2009 decisions, that would be an abuse of process, and that in the interests of case management, steps should now be taken to prevent such an abuse. The Supreme Court therefore directs that the 2008 and 2009 notices shall not have effect. This means that the appeals against those decisions have been finally determined in terms of the statute. The appeal against the Institute's decision of December 2012 to give notice of a fresh proposal to cancel the registration will be allowed to proceed. The Court expects these proceedings to be brought to a conclusion as expeditiously as possible.